of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for argument in CV140427, Kirkland versus Old United Casualty Company. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and Mr. Stone, as the appellant, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we have conferenced the case prior to argument. So with those preliminaries, Mr. Stone, you may proceed.
Thank you, Your Honor. Randall Stone. I represent the plaintiff, Daniel Kirkland, who's the plaintiff and appellate in this matter. And we have another motion for summary judgment case. Just a little background. Plaintiff is a pilot. He purchased a replica 1941 Focke-Wulf aircraft. It was used by Germany in World War II. He insured the aircraft with the defendant, Old United, and subsequently had an accident at the Casa Grande airport and submitted a claim, which was denied. The Focke-Wulf is a single-seat aircraft. There is no tandem aircraft that one can train in. So this type of aircraft, the first time you fly it is the first time you fly it. I'll start a little bit and talk about the letter of authorization.
We know you submitted a letter of authorization. There was also the policy. I'm assuming he received and read the policy.
He did.
Okay.
The letter of authorization is issued by the FAA for certain aircraft, and the Focke-Wulf came under that authorization. And in that case, an aviation safety inspector from the FAA comes out, understands what aircraft's going to be flown, looks at the pilot, his airman certificate, his ratings, make sure that his medical is up to date, that his BFR, biannual flight review, is up to date, and that he looks at his logbooks and determines that he's qualified to fly this particular aircraft. They're issued for 90 days at a time. There's no limit on the number of LOAs that you can get, although at some point you certainly try the patience, I guess, of the aviation safety inspector.
But it's your position that he was not required to have that on the date of the accident?
That's correct.
And why is that? Because the CFRs, as I read them, would seem to equate the letter of authorization as being in lieu of a type rating, and that it would be required for an experimental aircraft such as this one.
Well, I think it's more of housekeeping. In this case, what happened was Mr. Kirkland thought it had been issued for 90 days at a time. He thought it was going to be 90 days, and it wasn't. For some reason, they shortened the date, I guess, to try to get him to hurry up. So this particular flight was 4 days after the letter of authorization had expired, and no new one had been issued.
But so how is it that he wasn't required to have one? I understand he might have been mistaken, but that doesn't vitiate the requirement that he have one in the policy.
In the policy, it says he has to have the necessary certificates and ratings, and I think it's undisputed, and I think the defendant in their filings have said that. A letter of authorization is not a rating, it's not a certificate. And in the policy, Old United could have said, you must have, for this particular aircraft you're insuring, and they knew what the aircraft was, you must have a valid LOA. And they didn't. In their language, it says you've got to have the proper ratings, you've got to have the proper certificates, which is, we don't argue with that. But he did. He had the proper ratings, he had the proper certificates. And so I would ask the court to take a look at that. The LOA is not a certificate, it's not a rating, as spoken and required by the insurance policy. And the FAA took no action against Mr. Kirkland. In discussing the LOA, the FAA notes this authorization may be listed on an airman certificate designating other authorized aircraft that the airman is qualified to fly. Again, because the Focke-Wulf is a single-seat aircraft, there is no tandem to fly. They allow pilots to fly a similar airplane, and in this case, Mr. Kirkland had flown the P-51 Mustang, which I think everybody's familiar with, from World War II, and it has basically very similar flight characteristics to the Focke-Wulf, is the reason it's used. The stall speeds, the turning speeds, the approach speeds, and the handling is similar to the Focke-Wulf. So Mr. Kirkland had flown the P-51 Mustang. That's part of what he did to get checked off by Lee Lauterbach.
So your
his
position
logbook.
is that under the policy, he wasn't required to have a check ride or an observed ride in this particular model, and that the other check ride, even though Mr. What's his name,
Lauterbach.
Didn't his sign-off basically say he's ready for the next step, which is to be certified in this particular model?
He did. The way that works, everything goes on your logbook. And in this case, since Mr. Lauterbach couldn't fly with Mr. Kirkland, what he could do is examine him, talk to him, look at his logbooks, look at his ratings, decide that was his job to decide, is Mr. Kirkland ready to fly this aircraft? And that's the only way he could do it, is to sign off in his logbook. And in the logbook, and there's no dispute that this is fraudulent, it's his logbook. Mm-hmm. Mr. Lauterbach was chosen by the insurance company. They put his name in there, and Mr. Kirkland agreed to it. And he signed off saying that Mr. Kirkland was proficient to fly. So the next step is, what do you do? Well, you fly the aircraft for the first time. And I think what O United is doing is trying to come up with the catch-22. They're saying you can't fly the airplane until you're qualified, and you're not qualified because you haven't flown the airplane. So that's a conundrum. So
Well, it also, part of that seems that, at least as I see it, he would have to fly 24 solo hours.
That's correct.
Before the insurance would kick in?
Yeah, and that's again, it's nonsensical. Mr. Kirkland bought insurance. There's a start date on the insurance policy. He paid close to $17,000 for insurance. Would he do that knowing that we would have to fly his plane 25 hours uninsured? In that case, he would simply not get any insurance, fly the plane uninsured for 25 hours, and then get insurance. So where the 25 hours comes in, Mr. Kirkland was qualified and signed off to fly solo. His intent was to get a type certificate. And what the insurance company is saying, you can't fly forever without getting your type certificate. You've got 25 hours to fly, and then go and get the checkout and get your type certificate in the N190.
Was there a way, and I don't necessarily see it, for him to have coverage by paying extra for the first 25 hours?
Nothing was disclosed to him, and his understanding was, I think reasonably, when he looked at the policy, read it, that he was insured. Once he paid his premiums and he was qualified, he was listed as an approved pilot, and we're not arguing that just because his name is there, he was qualified. But he was approved, and the insurance company certainly looked at his credentials.
But let me go back to something you're talking about with the check ride in the other aircraft. The policy language says, and I'm quoting, Dan Kirkland is required to receive a check ride and sign off by Lee Lauterbach in the same make and model aircraft insured herein. That didn't happen. That
was impossible.
It was impossible for him to fly with your client, yes, but as you noted, and as the CFRs contemplate, there are other ways of providing that practical test when it's a single-seat airplane, and that didn't happen in this make and model.
It couldn't happen in this make and model. In other words, it's a single-seat aircraft. There is no tandem. Obviously, he can't fly with Mr. Lauterbach in the aircraft.
But the FAA regulations, I'm looking at 14 CFR section 61.63 and 61.45, that a practical test can be conducted in a single-seat airplane if the examiner is in a position to observe the applicant during the practical test. The inspector observes the applicant from the ground or from another aircraft, and that didn't happen here.
That, I believe, was the sign-off. That's when Mr. Lauterbach signed Mr. Kirkland as being proficient to fly the aircraft.
In the TF-51 Mustang.
Yes, but the logbook endorsement notes that not that he wasn't proficient in the P-51 Mustang, but he was proficient to fly the FW-190.
Really? It said that? Didn't it indicate that he was ready to proceed with the FW-190 check ride?
The check ride would be, it's not a ride, it's a flight, because two people can't get in there, but that was the flight that Mr. Kirkland took when he veered off the runway and damaged the aircraft.
I don't recall that it said what you're saying it said. As I read it, he signed off that under the TF-51 Mustang in January 2012, he was proficient, and that he was now ready to proceed with a check ride, or however you want to characterize that, giving that it's a single seater with the FW-190.
I agree, Your Honor, and that was the flight. That was the first. This was the very first flight that Mr. Kirkland had taken in the F.
Right. So there was no check ride on that aircraft model.
Again, there couldn't be a check ride. It has to be Mr. Kirkland flying the aircraft for the first time.
Yeah.
With
This is his first time to fly that airplane, so there is no way that as to that airplane, there was a check ride, an observation from another plane from the ground, anything of him flying that, such that that he's required to receive a check ride before he can be an approved pilot. It just seems like that's fatal. All these other things aside, I don't know how you get past that one requirement that is unambiguous in the policy.
Other than this was the check ride. This was the check flight would be the more, in this particular aircraft, I think, check flight describes it better than a check ride. But this was his check flight. This was his first flight after being approved by Lee Lauterbach. And the only way Mr. Lauterbach could approve him is by logbook entry. So again, I think that goes back to the conundrum that you can't fly the aircraft because you're not qualified, and you're not qualified because you haven't flown the aircraft. And the only way to get around that was what they were attempting and did do, was have Mr. Lauterbach examine Mr. Kirkland, look at his certificates and ratings, look at his previous flights in the P-51, and decide if he was qualified to fly it. And he did so. And again, I would just state that the letter of authorization is not a rating, is not a certificate. Mr. Kirkland held a current medical certificate. He held all the necessary ratings, and he had the necessary experience as stated by Lee Lauterbach in the logbook entry. And as to, I think I've addressed it, the 25 hours, I think, would be against public policy to say that you're going to buy insurance, pay the premium, and then have to fly your aircraft 25 hours before being insured. United makes another statement that because in this flight Mr. Kirkland ran off the runway and did some damage to his airport, that he must not have been qualified. Well, pilots who are qualified damage aircrafts all the time. That's why we have insurance. So I don't believe the insurance company can say simply because you damaged your aircraft, you weren't qualified, and we're not going to pay. So I think they were asking Mr. Kirkland to do the impossible in this case, as far as the check ride is concerned. The decision in the lower court did not state a basis for the granting of the motion for summary judgment. We believe that there are several material issues of fact to be addressed in this case, and I will save the rest of my time for any rebuttal unless there's some more questions. Good. Thank you.
Thank you. And Mr. Sifferman.
Thank you, Your Honor. May it please the Court, Mark Sifferman on behalf of the Appley Old United Casualty Company. If I could first address the argument that the requirements for Mr. Kirkland to be an approved pilot under the policy were impossible to meet. The problem with the appellant's argument is they are not reading that policy language plainly. It does not say that he has to get a check ride in this particular piece of equipment. It says he has to obtain a check ride in that make and model of aircraft. I have a Volkswagen, not without the fake software. I have to get, assuming we have a similar situation, if my policy said I had to get a check ride in that make and model before my vehicle is insured, what I have to do is go get another one at a training facility and take a check ride, a practical test in that vehicle. And obviously, I think maybe implied by Judge Portley's question, that's going to be insured not by this policy, but by the training facility's policy.
And is that also the answer to Mr. Stone's argument that, well, it's illusory because you can't do 25 hours of solo flight without insurance? And so is that the same
Absolutely.
situation?
Absolutely, Your Honor. Because these are all requirements before, not Mr. Kirkland is insured, but before that particular piece of equipment is insured with Mr. Kirkland piloting it.
And what about his argument about the Mustang? Am I confused, or is that a completely different make and model so that it really doesn't matter what Mr. Lauterbach did on that?
Your Honor, you are exactly right about what the CFRs and the FAA documentation say. Usually, a practical test, a check ride, is done with the instructor inside with the pilot, but there are planes that are just single seat. And the regulations and the documentation take that in consideration and say, if the instructor feels confident that they can do a sufficient practical test check ride from the ground and be able to view the trainee, they can do it that way. It may be that, I'm sorry, I'm going to make that argument.
I was going to say, would a British Mosquito, well, and I don't know if the British Mosquito would be a comparable World War II airplane, which could be a two-seater, or whether there were any around. So,
and then one of the things stated late in the argument was that Old United was arguing that since the FAA found at the reasonable grounds that it was pilot error that caused the accident, that we necessarily were arguing that he wasn't qualified. I don't believe that argument was made in the trial court, and I surely know it's not made in this court. All we're saying is it's more important that the Arizona courts have found that causation in this area is irrelevant. That it doesn't matter that the qualifications or the conditions that were not met for coverage. It doesn't matter whether or not they had anything to do with the accident. If those conditions are not met, and the insured has the burden of proving that those conditions have been met, there's no coverage. If there's any other questions, Your Honor, I would end up.
Okay, so you've discussed the check ride / practical test, the 25-hour requirement. So, and maybe you mentioned this and it just went over my head, but the policy language that says that to be an approved pilot, Mr. Kirkland must have the necessary ratings as required by the FAA for each flight. I heard Mr. Stone argue that there was no requirement for this particular aircraft that he have within the language of the policy, pilot certificate or necessary ratings. What did the FAA regulations require?
I believe we cited the FAA regulations in our brief, and my reading of them is at least they are in lieu of, quote, a certificate or a rating. That was a second argument in the summary judgment motion. The first argument is those other three conditions about that had to be met before he was an approved pilot.
So it's just an alternative argument that you're saying is not technically necessary to reach if these other requirements were
Absolutely, Your Honor. But slugging through the regulations, I think you can come to that conclusion, but it's tough to get there. And there's one thing that should not be forgotten. We talked about the Lauterbach check ride and the 25 hours, but the third condition was completing a check ride with Stuart Dawson. There is no question that that did not happen in any plane. And that's admitted in the plaintiff's summary judgment response, which is at pages 77 and 78 of the appellant's opening brief. He had not completed a check ride with Stuart Dawson, paragraph 4 of their statement of facts. Thank you, Your Honor.
Rebuttal, Mr. Stone?
Thank you, Your Honor. Just on the issue of whether or not they're alleging that he didn't complete a check ride in the aircraft, and I'm reading from the defendant's motion for summary judgment. Quote, defendant also stated that plaintiff received a note in his logbook that he was proficient to fly the FW-190 aircraft from Lee Lauterbach. He did not complete a check ride with the plaintiff in a FW-190 aircraft. So,
But I thought he was focusing on the policy language, which also requires Lee Lauterbach to certify the same make and model aircraft 25 hours solo before completing a check ride with Stuart Dawson.
right, the check ride with Stuart Dawson, and that was his plan to have the first flight to fly 21 hours with an insured aircraft, then to get a check ride with Mr. Dawson. And once he had the check ride with Mr. Dawson, then he could get the type certificate. Then, if he wanted to, he could be like Mr. Dawson or Mr. Lauterbach and approve other pilots who may want to fly the 190. So that was his ultimate goal. It's a progression to go through, and this, again, was the first flight. Defendant says that as far as his 25 hours, well, we weren't giving him any insurance for the 25 hours because he had insurance elsewhere. Well, I don't know where this other insurance is. This was Mr. Kirkland's aircraft. He bought insurance on this aircraft.
I didn't hear him make that argument. The argument I heard him make was in response to your argument that the 25-hour requirement rendered this policy essentially illusory, and his response was it wasn't, because he could have gotten 25 hours in a make and model, not the plane he owned, with somebody else's insurance in order to qualify, so it wasn't an illusory insurance policy.
Well, I disagree. It makes no sense for Mr. Kirkland to buy this aircraft, to insure it, and then to go and, I guess, rent another aircraft that would be insured. He couldn't buy another aircraft. He would have to then rent an aircraft that would be insured.
Well, whether it makes sense or not, I mean, it's the policy he chose. It's just that there was a mechanism whereby he could get insurance for this plane. He just had to jump through some hoops to do that. And
well, yeah, I would again argue that's illusory, that to force him to buy an aircraft and then go away and rent a 190, that's almost impossible to do, to get in 25 hours to then come back to fly his airplane finally with insurance. It's just nonsensical. And just in closing, yes, any pilot who owns an aircraft can go to a flight school or somewhere and rent an aircraft, and that aircraft would then be insured, probably by that school, although that school may come back against the pilot. There's problems with that. But Mr. Kirkland bought this aircraft, he insured it with the reasonable understanding that when he signed the policy and he paid his premium, he had insurance on his aircraft, and that he was a qualified pilot who had the proper certificate and ratings as required by the insurance, and got the sign off by Mr. Lauterbach, who was chosen by the insurance company, and flew, and just was that there was an accident and should be paid. We think there are genuine issues of fact in this case that need to be addressed by the Superior Court. We don't know what the basis of the Superior Court's ruling in this case, because it doesn't say. So if we have 2 minutes, if I have any questions that will address this.
No, thank you.
Thank you.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. And at this time, the court stands adjourned. Thank you.